Okay, everybody, I wanted to go ahead and discuss what we anticipate doing for everybody in the next couple of seasons, just because we've got some concern or um, uncertainty about how President Trump is going to handle the um, regulatory cap and then how they're going to handle the supplemental visas. And so we thought now is the best time to talk about all of these winter strategies that we have employed, that we've been successful in employing, and that you should consider if you've not already employed one of these strategies to ensure that we can maximize our ability to maintain our workforces for next spring. So the vast majority of this conversation is going to be about maximizing the opportunity to employ H-2B workers in the spring of 2026. So first, let's start with the glossary of terms, because it's critical that you guys all understand these four very, very important terms as it relates to the H-2B marketplace. First of all, there's the cap. So right now, there are 66,000 H-2B visas that are available pursuant to the Immigration and Nationality Act. Those 66,000 visas were divided into two groups of 33,000 allocations as a result of the Save Our Small Business Act amendments that were passed in 2007. What that means is in the H-2B market space, there are 33,000 visas that become available at the beginning of the federal fiscal year, which is October 1st, and then 33,000 visas that become available on the half fiscal year, which is April 1st. So those visas are allocated pursuant to the regulations. So the law allows for essentially 66,000 tickets to be available for workers for whom employers have petitioned the Department of Labor for a temporary labor certification. Now, for every single year since the Clinton administration, with the exception of 2001, okay, which is when COVID occurred, the administration or the legislature provides what we refer to as cap relief, which is an additional allocation of visas beyond the statutory 66,000 allocation. So for example, during the last 4 years, the Biden administration has released an additional 65,000 H-2B visas. And as part of the Biden administration's strategy, he's allocated those supplemental visas into 3 troughs. So he had a trough of supplemental visas beyond the 33,000 that were available on or after October 1 to satisfy employers who had a winter need. He also had a trough of supplemental visas available for employers who had a need beginning on April 1st. And then finally, he allocated an additional group of visas for spring needs beginning on May 15th. So for the last 4 years, our clients have enjoyed a pretty robust H-2B visa environment because the administration had determined that the regulatory cap of 66,000 visas wasn't enough. And as a result of our growing economy during those 4 years, President Biden projected that these visas would be available and employers were be able to react accordingly. So that was cap relief. Moving forward, we are not certain how the Trump administration is going to handle these supplemental visas. We just really don't know. It appears that we are pretty friendly with El Salvador currently. And so we should assume that there would be visas that were allocated and earmarked during the last 4 years for El Salvador. I don't know about our relationships with the other Northern Triangle countries, including Guatemala, Honduras, and then Costa Rica. But we can probably guess that El Salvador is probably going to get some sort of preferential treatment. But like I said, we don't know how the Trump administration is going to release supplemental visas, if at all. It's entirely possible that given his position on immigration, the Trump administration decides not to provide supplemental visas. And then we're all stuck racing for those 66,000 visas. So that is why the purpose of this discussion is to talk about some of the alternative strategies that we use to maximize our clients' ability to capture just regulatory visas, assuming that supplemental visas are not available. And in that regard, it is critical for us to understand what cap exempt means. Cap exempt means that a H-2B visa beneficiary was able to capture a regulatory visa during the federal fiscal year. And because he was able to capture the visa during the fiscal year, we have a situation where the subsequent readmission of that H-2B visa worker doesn't count against the regulatory cap. So we have a situation where if a worker enters under a winter labor certification soon after the federal fiscal year beginning on October 1st, that worker could return home during, say, the winter holiday, so Christmas, New Year's, Chinese New Year's, etc., and then re-enter either with that same winter labor certification or upon a different temporary labor certification that begins sometime during the springtime. So it'll be critical to understand the exemption that is applicable to workers who enter in October who are able to re-enter either during the winter period or during the spring period. And then finally, this is just for those of us who are dealing with some sort of cap relief in the forms of some sort of supplemental visas that traditionally, going back again, like I said, to the Clinton administration through the Obama administration, there was a carve out for returning workers, and there has been during the Biden administration as well. What a returning worker means is that you are employing or recruiting an H-2B available worker who has been physically present in the United States during the preceding 3 calendar years. And where there's a carve out is because we've already vetted that individual at a consulate during the H-2B process, and we have made a determination that he is admissible, there is a much lower rate or a much lower chance that that H-2B worker will abscond, right? So we've already admitted that worker. That worker has already met their national security requirements. It's not a criminal, and he or she returned at the conclusion of that temporary period of time and is thus a lower risk of absconding and remaining in the United States in violation of their visas. Okay, so this slide has been a slide that we've used consistently during the last, I don't know, 10, 15 years, and that is because every time there is some sort of visa relief, USCIS is clear to indicate that there are certain H-2B visa holders who can remain in the United States for upwards of 3 years. Okay, that is critical for you guys to understand that there is a distinction between the temporary labor certification period that is authorized by the Department of Labor and the length of time with which an H-2B visa holder may physically remain in the United States. So for those of you who are adept at the H-2B visa, you are aware that the temporary labor certification period is 10 months. Interestingly, the legislature is the one that identified that it would be a 10-month period of time because the Department of Labor originally wanted to limit it to 9 months. But over the last couple of groups of appropriations, the legislature has extended it to 10 months. So the longest you can have a temporary labor certification based on traditionally either a seasonal need or a peak load need is 10 months. However, by regulation, an H-2B visa holder may remain in the United States for a period of 3 continuous calendar years. And most of you will be asking, well, how is it that that worker can stay in the United States for 3 years when the Labor Department only allows them to qualify for a temporary need, and that temporary need is capped at 10 months? The answer is that H-2B worker can work for multiple employers. So the easiest example to illustrate what it is that allows a temporary worker to remain in the United States for that 3-year period of time is similar to a situation with H-2A workers where the worker enters the United States and assists with the harvesting of peaches in Georgia, for example. And that peach harvesting season is during the summer and the fall. And then that same worker travels to Washington State to pick apples, which occurs during the winter and the spring. So that same worker can travel between 2 employers who have separate and distinct seasons, but that worker can remain in the United States upwards of 3 years. So for a lot of you, we have tried to extend that kind of situation into the landscaping area. And for those of our clients who are in the Northeast United States or in the Rocky Mountains in the Northwest, the easiest way for us to justify a landscaper remain in the United States for upwards of 3 years is to have an opportunity for snow removal. So they do snow removal during the wintertime and they're landscaping in the springtime. And as long as there's 2 distinct companies, they can be related, they can have similar ownership, but as long as they are distinct FEIN numbers, that worker can jump between one company during a temporary need to another company to a temporary need. So what you need to recommend or what you need to realize is that we can either extend the admission of your H-2B workers, or we can transfer those workers between employers and not have to worry about the visa cap. So when I talk about cap relief, what I'm really talking about is gaming the exemption that's applicable to a H-2B visa holder to allow them to remain into the United States for upwards of 3 years. For those of you who have, we've had these discussions at length, what we are basically doing is we are admitting someone, for example, with a ticket into a movie theater, and then that patron is jumping between movie to movie. So although they purchased a ticket to watch one movie, they're entering the theater, and after that movie is concluded, rather than leaving, they're just jumping into the next theater. So that's what we're doing from an H-2B perspective. We need to be very patient with the administrations as they release supplemental visas. We were very fortunate during the Biden administration in that the Biden administration relaxed the anxiety associated with supplemental visas by not only announcing the supplemental visa release before the beginning of the federal fiscal year, but in doing it consistently. We knew what Biden was doing during the last 4 years, and everybody has benefited. Like I told most of my clients, even if you were in either the E, F, or G lottery group for the April 1 temporary labor certifications, all of our clients have received visas. And that's because as a group, not only have we employed these strategies, but we also have basically a credit union of available visas that can be used amongst our clients. We basically created a bank, and even if you run afoul of either the regulatory cap or even the supplemental cap, we've got extra visas for you. So remember that you can also exempt your own workers, even if you don't have a second company with a winter need, by utilizing your spring labor certification with an October 1 start date. So how does that work? Realize in the scheme of all H-2B processing, all of those that are in this H-2B business, we are very aware that there is a pretty significant distinction between a spring need and a winter need. And for the most part, the need in the country for October 1 H-2B workers is significantly lower than the need for spring workers. So the spring need generally outpaces the regulatory visas, and we're only seeing now that the winter need sometimes outpaces the regulatory visas, but generally those October visas are available well into December. So there's a lot less competition for October visas than spring visas. So if we are getting into a situation where we are not aware whether or not there's going to be visa relief, and we don't have a winter company with which we can transfer workers to, or at least bank those visas in order to take advantage of the exemption for the spring need, what we can do is we can use our existing spring labor certification as justification to mobilize those people in October. And I know that sounds crazy if you've got a need from, let's say, April 1st to December 31st, and you miss out on your supplemental visas. You could still apply for an October 1st to a December 31st labor certification. And the reason why you would do that is because the workers who enter after October 1st would be exempt from the next spring. So essentially, you are guaranteed to have those workers available to you, even if you only mobilize them for a couple of months at the end of the year. So it's critical to understand that that is another strategy. Obviously, the strategy that I want most of you to employ is you got a spring need, and we have discussions and we talk about the best case for you, and we create a different company if you don't already have a separate company, and we justify a winter need so that you have to take advantage, or you will have the opportunity of applying for that less competitive October 1 visa release date so that your workers can be exempt for the spring to ensure that they get here. The bottom line is, if we are able to either justify a winter need for you or utilize your existing spring temporary labor certification with an October 1 start date, you're guaranteed to get the workers in March or April of the next year. It's just a guarantee, and that's because they'll be exempt from the cap. So that's why it's critical now to have these discussions. Now, one of the other alternatives that a lot of our clients employ is, for most of our landscaping install clients, they actually have a nursery as well. And we are able to mobilize the H-2A workers because there is no cap, and then transfer those workers to an H-2B opportunity. A lot of our clients have used that successfully. There is some pushback sometimes from USCIS about transferring to an H-2A, but we have been able to persuade most adjudicators on RFEs that there is no prohibition from transferring an H-2B worker or an H-2A worker to an H-2B opportunity. The reason why we're having these discussions now is because prevailing wage determinations are taking upwards of 45 days in order to obtain. We need to have your prevailing wage determination on July 3rd. So we essentially have all May and all June to apply for a prevailing wage, for you to file your June 3rd temporary labor certification, July 3rd temporary labor certification for October 1 start date. It's very interesting, but my group has gotten very used to working on two holidays, on New Year's Day and on July 4th. And so what we can tell you is, over the next 2 months, we really need to get a handle of how we're going to justify your winter need, because we just don't know what Trump is going to do with the supplemental visas. I would like to say that He's probably going to follow his activities when he was in office the first time, but realize that he's the only president in recent history, all the way back to President Clinton, who had a year where they didn't release supplemental visas. And so you're talking about a situation where, basically the visas that we were used to, 140,000 H-2B workers, drops down to 66,000. And that could have a significant impact on your business. So if you are frustrated with the H-2B process because you are concerned that this is going to impact your business, now is the time for us to invest in identifying a winner opportunity so that we can apply for those temporary labor certifications on July 3rd. With that, I'll go ahead and let y'all go. I really appreciate your attention on this. And obviously, if you have any questions, give your paralegal or I a call. It's best to email because we can track all of you that way. And anyway, have a great remaining part of the day.